I don't practice family law, but I know somebody that does.
That's me, Mark McMann. Same location, 3001 Bartow Road, McMann, PA. Family law, again, divorces, adoption, child support, child custody, now called time sharing. We also do wills and trusts and military law as well. Give me a call at 863-393-9010. That's 863-393-9010. Or visit me at McMahonlaw.com.
Mark, I was on YouTube, and I don't go on YouTube a lot, but you had told me that the show we taped last week with Mayor Galfields, by the way, thank you, Mayor, for coming on, was going to be posted on YouTube, and it's also going to be on a website that we now have.
Yes, it's called LawTalkFlorida.com.
There's like a whole bunch of law talks. I thought I was so smart when I came up with the name Law Talk, and apparently there are law talk shows throughout the United States.
Yeah, no, there are 5, 6, 7, 10, 20 of them. But we're the only one that has a setup like this. We are the only one with such an aesthetically pleasing set, as well as it just looks good.
It's very professional.
Very, very professional.
You would think we actually prepared for this show.
You would think.
Yeah. All right, so we've got this. So, folks, if you want to listen to the show, you can listen to it at WLKF website, or you can go to lawtalkflorida.com and you can see it tape, because we're now taping these. Not taping like audio taping, but video.
We are videoing them. And we video them and we get them up rather quickly within 24, I think it was 48 hours last week, but we're working on getting it up quicker, and eventually we plan to live stream. We just have some technical things we need to deal with.
Well, first of all, we've got to deal with the fact that I had to move over a seat.
Yeah, when people click on, when they get on lawtalkflorida.com and they look to see what this video is all about, and if they look at the one from last week, from the 26th, I think it was, with Mayor Galfields, they will see you sitting in the seat closest to the camera. However, we have made a switch this week.
Yes. They're
going to see that you take up a lot of the screen.
Yes.
Why
I have a huge head,
yeah.
And there's really nothing that can be done with it. So we just try to stick me as far back in the corner as possible.
In the dark.
Yeah. And unfortunately, there's nothing I can do about it.
You also had a funny thing going on with your wrist.
Yeah, I was flicking the wrist back and forth. It's like, hello, welcome to Law Talk.
Yeah.
So I'm not doing that today. I'm facing the camera, very straightforward, manly, hard-charging attorney that I am, and we're going to tackle the issues of the day.
And we have a very special guest.
Yeah, we do. My good friend Cooper Lord. Cooper graduated from University of Florida and then went to Florida State Law School. He's been a prosecutor since August of 2010. He was on the show a couple of years ago, but apparently we didn't let him talk at all. So
well, I don't remember what that was all about. He maybe can fill us in. Maybe, that was the right way to go, and we'll realize that after today.
Yeah, exactly. Well, we'll see. We'll find out. Cooper, thank you for coming on.
Thank you very much for having me.
What we're going to do today, folks, if you have any questions for us, give us a call at 682-1430. That's 682-1430. What we're going to do today is we're going to take a look at the criminal process from a prosecutor's perspective. You guys have heard, men and women have heard me talk about how a criminal case works through the process, because I am a former prosecutor. I know a little bit about how the job is done, but we have somebody who's currently a prosecutor. I'm sure things have changed a little bit over the years, and so he's going to help us out in that regard. And we'll go ahead and get started. Cooper, how does a case make its way to the state attorney's office?
Well, originally it starts with an offense report or an arrest report. Basically, someone does something against the law, and they're either
allegedly
they're either caught or someone files a report and they get picked up later.
Okay.
So it goes in with. I think that different offices throughout the state may do it differently, but in our particular office, in our area, you have an intake area, and then you have the trial lawyer division, the violation of probation division. Is that right?
Yeah, that's correct.
So how does that work? The intake, what do? They make the choice?
Absolutely. Well, so they'll get in the arrest report, be it a citation, traffic citation, or whatever, and they'll take that and see whether the charges that have been filed or the charges that are in the report, whether we decide to file on those. And so they'll take statements at that point. They'll look at the state of the law and see whether we can prove whatever charges that have been filed by the officer, and then we file on whatever charges we deem appropriate.
That's an important distinction, because a lot of folks think that the law enforcement officers file charges. Law enforcement officers are doing the best that they can. They're out there on the field. They make the call. We certainly give them the benefit of the doubt with respect to the lower standard of proof being probable cause. But they don't have the benefit of a law degree and years of experience, honestly, sitting in an office dissecting various statutes to see which facts apply to which statutes. So oftentimes, and it certainly is no slight against the officer, but there are many times when a case comes in and the state attorney's office will change the charges altogether. They'll upgrade them or they'll reduce them.
Yeah, absolutely. I think a key example would be a mutual combat type of situation where there's a fight that breaks out, both people get charged with a battery, for example, and if each one of them are fighting each other, it's kind of just a mutual fight, then we might not decide to go forward on either of them. And so,
Or you could charge a fray, or you could charge disorderly conduct.
there's all kinds of options.
Yeah, but as an example, sometimes a person will come in and they'll be charged with aggravated assault. And your office will say, well, no, what happened here when they fired the gun at the person, that was more than just aggravated assault. That could be attempted first-degree murder. Or sometimes it will come in as attempted first-degree murder, and your office will conclude, well, there's not enough evidence of premeditation or not enough evidence that he was actually aiming at the person to kill him as opposed to simply to scare him, and you might reduce it down to aggravated assault. That's a good example.
No, absolutely. And I think it's also important to know that the intake attorneys only have the information that's provided to them. So they expect for the line attorneys, and I'm an assistant state attorney, I'm in the felony division. At that point, we have the opportunity to check in with the witnesses and do additional investigation if we need to, speak with detectives and determine whether the charges that have been filed we can prove, or whether there are other charges out there that haven't been filed that need to be.
When somebody's arrested, I mean, obviously, like I think you did over the weekend, you're there for whether or not first appearance hearings as to whether or not somebody gets a bond.
I wasn't arresting people over the weekend, if that's what you're saying.
No.
You do have a badge, though, don't you?
Yeah.
I do,
Isn't that thing awesome?
It's pretty nice.
Yeah.
Helps you get out of traffic tickets and whatnot.
No, he cannot admit to that. Take the fifth, Cooper.
So you're there early, and like every once in a while, you draw it just comes around to being your rotation. You have to go in there on the weekend because people within a certain period of time after being arrested, they get to go before a judge, right?
Yeah, absolutely. It's 24 to 48 hours, and they go in front of a judge, and the judge at that point determines whether there's probable cause to hold them. They decide at that point to set a bond or not to set a bond, depending if it's a very serious charge, then they can decide not to set a bond. Or if they're out on bond on a previous case, then they might have their bond revoked on that case, and they might have to stay in jail as a result of that.
You had one over the weekend, I think, that was rather interesting. In fact, it made the paper, did it not?
We're not supposed to talk about pending
that's
cases
right.
that are working their way through the system.
That's
Let me clear up this whole thing about first appearance hearing, and I think a lot of people are surprised when I tell them that. First appearance hearings occur every day of the year. They have first appearance hearings on Christmas Day. I had to do them on New Year's Day one time. Every single day of the year, because when a person is arrested, they have a right to go before a magistrate or a judge within 24 hours of the arrest, depending when they get booked in. Sometimes it rolls out to 48 hours. So the judge can determine whether or not there's probable cause and what, if any, bond is set. And so our prosecutors and public defenders and jail officials and judges are down at that courthouse 365 days a year. Folks, we're going to take a break and be right back.
Mark McMann. I started McMann, PA after serving 10 years as a United States Army JAG Corps officer, as a military lawyer. That experience instilled in me certain attributes, including dedication, loyalty, sacrifice, hard work. I have made those attributes the cornerstone, the foundation of McMann, PA. If you're going through a divorce, a paternity action, a child custody battle, or perhaps a child support battle, call us at 863-393-9010 or visit us at McMahonLaw.com. We are with you, honest, hardworking, and loyal every step of the way.
And McMann, PA. Mark, let's talk about the great shows we've got coming up in the weeks to come.
You know, actually, we're in the works of getting one of the Tim Harris, who's with the. He hasn't been here in a while, but with the school board, he's going to come on and fill us in.
I thought he was mad at me because of my rant on the new magnet school process.
He said our people need to get in touch with his people and arrange his fee, and he will be on.
Arrange his who?
His fee.
We got to pay him to come on?
We got to pay him to come on now.
I'm not paying him anything to come on.
No, he said he'll come on. We're going to work on that for sometime late July.
Okay.
We are in the works of getting Dennis Ross.
Dennis Ross, yeah. It's just a matter of when we can get him to come on. I'd like him to do it live because we've got this amazing video equipment here. But we'll have to wait and see.
He'll be able to fill us in on all the big things: the repeal of Obamacare,
yes,
the election coming up.
I'm not sure that has been repealed. Perhaps
no, the
reading
pending,
in the future.
Yeah. I think on July 9th they're setting the date for that. But all exciting things. I mean, this is the silly season. This is the political season, and he'll be able to fill us in.
He's doing a good job with that. That whole post office thing has landed on his lap, and that has not been an easy gig for him. And he's done some tremendous things and just providing steady leadership. It's I mean, the post office as an institution has been for 200 plus years, and it is in desperate financial straits. So I don't know what's going to happen.
Yeah, but at the same time, I kind of got irritated. There was last weekend, I believe, I was watching television, and there was a post office commercial. It was obviously the union or whoever they organizer or whatever they're called. But it was on one of the big news channels, and it was not the only time that I'd seen it, complaining about how we need to save it and how bad it is. And I understand the tradition, but at the same time, you know what, if you're not getting the job done, it is what it is.
Well, I have mixed feelings about the post office. I think there are, if the post office, if we call it a business, what business would be made to open up outlets in the middle of nowhere? Okay, you can't make 7-Eleven open a store where there's 30 people that live in a town, but you have, Congress is going crazy every time the post office says, okay, you're cutting our budget, we got to do what we got to do, so we need to cut this post office here, we need to cut it here, and we cut it here, and they can't do it. And so, the very nature of their operation is one that is not profit oriented, and then we complain because they don't turn a profit. Well, I don't know. I don't know what the answer is. I think the unions certainly have not helped. We've got, you've got the Postal Carriers Union, you've got the Mail Sorters Union, you've got all these various unions. And apparently, I just did not know this. Watching this thing progress through the legislative process, I've seen stories and read stories about where you'll have a post office and they'll need help up front, but the people up front are not allowed to go up there and help out. And so a postal carrier cannot do the job of a mail sorter. The mail sorter cannot do the job of a postal clerk. You've got all these various unions representing everybody. It's like, shouldn't we all be on the same team, rowing in the same direction?
Maybe they should get a bailout that's tied to renegotiating the contract.
That would be good. Mm-hmm. That would be fine. So anyway, we'll have Congressman Ross coming on and talking about that. I'm not so sure if we should be giving the post office a bailout, but we certainly need to be.
Joking.
Yeah, I was joking about that, but we certainly need to do something to revisit some of these asinine union contracts. I'm not anti-union. I don't really have a problem with it, but when the power of the union gets so strong that it strangles the very institution it's supposed to serve, it doesn't seem to make much sense.
I
think the reason that unions were created and came about in the early 20th century was for working conditions, dangerous working conditions, and unfair wages.
12-year-olds aren't working in factories.
Well, yeah, exactly.
Not here.
It's an Upton Sinclair type situation where these horrible working conditions, and that's not the situation anymore. And so I don't want to say that they've outlived their usefulness. I think they still provide a service to some folks, and in general, I don't really have that much of a problem with them. But sometimes it's not always about what's best for the union. It should be a combination of what's good for the worker and also what's good for the company.
The one thing that irritates me is every time I see one of these union bosses, one of their leaders, they all have a very thick mustache.
And a pinky ring.
And a pinky ring.
Yeah.
I don't know.
You should get you a pinky ring.
I've thought about it.
Yeah. I don't think too many Florida guys have pinky rings.
Down South Florida guys.
Yeah, maybe.
Yeah.
I don't know. So we're going to have him come on. And then Tommy Ray, former FDLE agent Tommy Ray, he just retired. Congratulations to Special Agent Ray. He did some amazing work for the Florida Department of Law Enforcement for quite some time. He had promised.
Is he a consultant on the show? Or?
Yeah, he was. I don't know if that show's still on. I probably should admit that. When Tommy comes on, I'll have to swear up and down how much I love the show. And,
I think it is. I think it's
still on.
Yeah.
No, I have no idea. But he was a consultant for a show. I'm not sure if it's still on. I don't really watch. Well, I don't. I got a 5-year-old and a 3-year-old. I collapse in bed around 9:30.
Jeopardy.
I do watch Jeopardy. Yeah, I'm a lunatic. Anyway, it's a crazy life that I lead. Tommy Ray has told me he's going to come back on, so we're going to have him come back on. And Bob Laddig is formerly with the Department of Corrections, the Probation and Parole. I have tried for a long time to get somebody from the Department of Corrections, Probation and Parole Department. There's really not much of a parole department anymore. Department of Corrections Probation to come on and talk about what it is that they do, and I haven't had much success because most of the marching orders come from Tallahassee. The local branches don't have much in the way of independence or discretion in doing that sort of thing. So I've asked a couple people over the years, several people over the years, and they said, "Oh, I'll get back to you," and they never do. Well, Bob Laddig has listened to the show over the years. And he said he would be happy to come on. He's no longer with the Department of Corrections, but he was a supervisor, and so he would be a good person to talk to. My wife, as you know, Mark, was a former probation officer.
Yeah.
I'm very proud of her. She worked her way through college as a clerk for the Department of Corrections, and she worked her way through the first couple of years of law school as a probation officer, and now she is a prosecutor at the same office that Mr. Lord works at.
As a matter of fact, has she been on the show yet?
She doesn't much care for the show. She likes Ask the Preacher much better.
She doesn't even listen to it. And the kids cry when they hear it.
They don't.
In the car.
They think I'm yelling at them. I don't know. That she likes the show, but in terms of coming on, she's never she's never asked. It's kind of weird now that you think about it. Okay, honey, you can come on the show anytime you want if she's listening, but I don't
You're
think
looking
she
for a
is.
prosecutor. I mean, you got one living at home.
Yeah,
right?
you know, we talk shop enough as it is.
Yeah, fair enough.
Yeah, let's let the worlds are colliding. You know, we'll let her do her thing. I'll do my thing. Anyway, so we're going to have him come on, and that's about it. That's enough guests. Let's talk to the guest that we have right here. Let's not neglect our current guest, Mr. Cooper Lord. If you have any questions for us, give us a call at 682-1430. 682-1430. All right, Cooper, let's go back. Where we left off is a case that's made its way into the state attorney's office. It's gotten through intake. The intake folks have reviewed the facts, reviewed the law, and decided what charges to file. Sometimes they upgrade them, sometimes they downgrade them. Most of the time they stick pretty close to what the officers have come up with because these officers do a very good job. It now comes to your department. We're going to stay away from the whole arraignment process and program that they have to get rid of some of those cases. Let's say it's a trafficking case, okay? It lands on your desk. What do you do next?
Well, the first thing to keep in mind with trafficking cases or some of the very serious crimes out there is they've got mandatory minimum sentences. And so that's something you always have to keep in the back of your mind, that with trafficking cases, they can have mandatory sentences up to like 25 years and life even.
In this trafficking, when you say that, it depends on the amount that they were trafficking and the type of drug, correct?
Absolutely. So if we're talking about trafficking in hydrocodone, for example, you've got a different mandatory minimum sentence, mandatory minimum prison sentence for 4 to 14 grams as you do for 14 to 28 grams and then 28 grams and above. And so, yeah, it entirely depends on the amount that you have that you're caught with.
And that could pretty much put you in the driver's seat from the standpoint of, you know, there's no, if it goes to trial and they're found guilty, the judge has got to give them that sentence.
Yeah, exactly, and it's not discretionary. And
Absent the
Right.
youthful offender sanctions and that sort of stuff, 99% of the time it's not discretionary.
correct.
Okay. Maybe we should have taken an example other than well, you know, even a trafficking case. I think it's useful to point out that when this case lands on your desk, you're looking to, even though you could be, if the person were convicted, 15 years, no question about it, there are things that a defendant can do to help him or herself. For instance, they can engage in what's known as substantial assistance.
That's right, yep.
Let's talk about that for a second.
Okay, well, substantial assistance is basically cooperating with law enforcement to try to work other cases. If someone is, you know, the bottom peg on a drug enterprise, they might want to go up the ladder and try to catch the bigwigs or whoever. So maybe they would let that person go and try to get some information to arrest those people and try to get it at the source. And so if they do some substantial assistance, that might, in the end, in order to their benefit, give them a reduced sentence.
Yeah, let me tell you, folks, I'm not going to name their names, obviously. I've got a lot of good friends in law enforcement, but these fellas that do, and I don't think there are any women in the unit right now, but the men and women that are in the undercover drug unit, they do amazing work. And people think, well, it seems so unsavory to try to flip these defendants. That's what they have to do. That's how they have to cultivate these sources. And you know, when people talk to me about the drug business, and it is a dangerous business and it is a treacherous business. I have seen there is nothing like a 15-year minimum mandatory that will make a friend flip on a friend, a cousin flip on a cousin, a brother flip on a brother, or a mother flip on a son. I have seen it, and all the time. And not a mother on the son. That one surprised even me. But if you're looking at 15 years, I mean, you know, you're 25 years, you're gonna get desperate. And so that is part of the process, and that sometimes is the only thing that can keep somebody out of a long stretch of prison, is cooperating with law enforcement so that they can hopefully get somebody higher up the food chain. Now, you got this case, be it a trafficking or an aggravated assault or a burglary. What are you looking for before you make an offer?
Well, I think it's important to speak with the victim if you've got a case with a victim. So you mentioned aggravated assault. You obviously want to get their point of view because while the victim isn't necessarily the client of the state of Florida, they're still someone you have to consult with on those cases.
That's something that you probably encounter. I encountered it when I was in your position. Victims thinking that you are, in fact, their lawyer.
Yeah, and that's something that we hear a lot in the prosecutor's office. But the client for the state attorney's office is the state of Florida. So even with victimless crimes, which a lot of them are, obviously we wouldn't be consulting with a victim. We're thinking about the benefit to the citizens of the state, and ultimately sometimes that means putting people away so that they're not able to commit crimes on other citizens.
You talk about the victim or the alleged victim that calls you up on an aggravated assault. How much weight do you give to their requests?
Quite a bit of weight, but sometimes you kind of need to level with them and let them know what the situation actually is, that either a case is weak or there's all kinds of reasons why a case might not be strong. And so sometimes you need to let them know, well, maybe you do want to put them away for a really long time, but that's just not going to happen in this case for whatever reason. And
Well, a number of different reasons. Number one, I mean, you can't make an offer in one case simply because the victim wants a pound of flesh that is hugely disproportionate with the offers that have been made in 100 other cases exactly like it.
yeah, and the other part of it too is that there are victims that will call you and say, you need to be dropping this case. I want to come in and sign a waiver of prosecution. But we can't necessarily do that either.
Right.
You get that a lot.
Absolutely, yeah.
No, I mean, I remember that happening all the time. And, of course, you bring them into your office and you make sure that they do it. And in fact, if you're good, I imagine you've done this before, go on the record.
Go on the record?
Yeah, do you bring them in?
absolutely.
And
So we'll have them go on the record, absolutely, as to what the reasons are and that they're not scared of the defendant or whatever else.
What you're talking about is having them come into the courtroom so the judge can ask them questions under oath and they can state, why it is they want to drop the charges and how much they want to drop the charges and that sort of thing. And sadly, folks, the reason that it has to be done is because without a lot of these cases, they simply cannot be prosecuted without the cooperation of the victim. But you want to let that. Sometimes having the judge, sort of stick his hand into it, lets them know how serious this really is. To some degree, when the victims want to, it's just
call 2 months later.
Well, yeah, exactly. Or something should, God forbid, something awful should happen. It's like we tried to do everything we could. We tried to protect you from yourself. We know you filed the charges, or you called the police. The police were there immediately. We did our job. We've done everything that we wanted to do to try to protect you. But without your help, to some degree, we cannot go forward. And sometimes you do want to get them down there in front of a judge to make it very clear that this is their decision. We've done everything we can to protect them, but they are not willing to cooperate.
Right, and sometimes there's nothing we can do in a certain case if the victim's not willing to cooperate.
All right, folks, we're going to take a break, and we'll be right back with Cooper Lord from the State Attorney's Office.
We'll be right back with more of Law Talk.
Headbanging music you got going here today, Dan. Where's my 80s music that I love so much?
Is that 80s?
I don't even know what this is.
Yeah,
Mark,
that's certainly your. Yeah, that's
what
you.
is the
It's a
deal
lover
with
boy.
you wanting him to bring us in with George Michael?
Wake Me Up Before You Go.
The Wham rap. I heard
The
you were a
Wham.
huge fan of the Wham rap.
The Wham. Is that what that was? Wake Me Up
Don't
Before
even
You Go
start.
Go?
Is that what
That's
that
before
was?
my
Come
time. I don't
on
even
now.
know.
What are you talking about?
Well, you were telling me
Sound
on the way
crazy
over.
somewhere else. I'm not buying
This guy in the 80s used to wear those half shirts. You know what I'm talking about? People would cut them.
Yeah.
They might not have done this up north, but people would cut their shirts and say Nike on it. And they'd have guys that had short shorts, and they'd just be. You'd have a normal T-shirt on top, but just the bottom would be gone.
Actually, I've got some campaign shirts for the various candidates that are running for circuit judge or county judge, and I was threatening them that I was going to cut the sleeves off and cut the shirt in half and put on some
Short shorts.
yeah, some short shorts. Borrow a pair of your short shorts and some rollerblades and go around Lake Hollingsworth.
I think that would get votes. You'd vote for a guy that did that, wouldn't you? I know you would.
Run the other direction.
Yeah. Oh, it would be a horrifying sight.
Not only would you vote for him, but you'd probably invite him out for drinks.
Yeah, no.
No, we would not. No, we
Happily
would not.
married.
So that's not what I'm going to do.
Okay.
Anyway, Mark, listen. If you want to listen to George Michael, that's your business.
Yeah.
I don't judge you for it. Let's get back to the topic here. Cooper, the files landed on your desk. You're trying to figure out what am I going to offer in this case. What goes into the calculation?
It's not a file anymore because we've gone paperless at the state attorney's
Oh,
office.
you guys are such big time.
That's
it's-
right.
Yeah. Well, look, whatever. You
The
still call it a
computer
file.
Yeah, all right. So
Do you like that better? I mean,
Yeah.
is it kind of weird? I imagine at first it's kind of weird.
No, it's great. We got the dual screen, so we're working off both of them. It makes it more efficient.
So there's absolutely no paper involved. You don't have to carry this
no,
big.
we need paper for certain exhibits when we go to trial.
Well,
But outside of that, there's no paper.
wow.
Okay,
Very
let's
green.
get
Very,
All right,
very
that's-
green.
the quote-unquote computer file.
Yeah.
The file hits your desk. I don't care how it gets there.
Okay.
It gets there. What are you looking for?
Looking for, if I'm making an offer on a case, looking for the prior record of the defendant, looking for how serious the offense is, if there is any kind of a mandatory minimum, or if there's any kind of enhancement that the defendant might have based on their prior record. So looking at all of those factors and trying to figure out what an appropriate offer is.
When you say offer, you're meaning offer for them to plead to whatever it is that it could be a lesser, it could be the same thing that's charged, but for a good sentence that they may.
Yeah, absolutely. To work a case out. Plea negotiations are an ongoing process, and they can start either from the prosecutor side or from the defense side. But as just a starting point in negotiations, Or maybe sometimes, depending on the prosecutor, that might be the only offer that they get. And sometimes the prosecutor might not make an offer.
Yeah.
But say you make an offer, defense attorney might work off of that offer, try to suggest something a little bit more friendly to the client, and ultimately most cases get worked out through plea negotiations.
Some people are offended at the prospect or the concept of plea negotiations. They shouldn't be. What percentage? I don't know remember exactly what it is, but I think it's plus 90% are worked out via plea negotiations.
It's got to be upwards of 95%, I would think.
Yeah.
I mean, I've had 30 jury trials since I've been at the state attorney's office, but I've handled hundreds and hundreds of cases. So I would think, yeah, it'd be probably more than 95% of cases.
We try a lot of cases here in Polk County, and if we did not have plea negotiations, every once in a while you'll get some story that'll come out of Texas or wherever where the judge will say, I'm not taking any plea negotiations. Not that they should be doing that, but if we did not have plea negotiations, this system could grind to a halt.
Yeah, I just don't think that anything could get resolved. Cases would just be getting pushed down for months and years, because ultimately the cases have been created and they need to be resolved in some way or another.
Are you also looking for weaknesses in your case as a prosecutor?
Absolutely.
Yeah. Tell me why that is.
Well, sometimes you might have a motion to suppress that's not just something that a defense attorney will look for. I mean, a prosecutor, if they get a case and there's an obvious motion to suppress that's built into it, or an arguable one even.
When you say motion to suppress, you mean the defense has filed something to suppress evidence that you want to get in. What's the most typical situation where that happens?
I think you see that a lot in traffic stops, which is the beginning of a lot of arrests, really. So if there's some issue with the stop itself, then that can be the basis for a motion to suppress, which can suppress any evidence that was discovered after an illegal stop. So a prosecutor, the same as a defense attorney, might look for those issues to determine whether it's not a strong case and you might want to work it out for something less than what you normally would.
So when you say a bad stop, you're basically saying that would be a situation where at least the allegation from the defense is that law enforcement did not follow the procedure that they should have legally?
Absolutely. Yep. So for a bad stop, what I mean by that is that the officer did not have either probable cause for a traffic infraction, or they did not have reasonable suspicion to believe that there was some kind of criminal activity that was afoot. And if they don't have either of those things, then potentially any evidence that's discovered after that unlawful stop could be suppressed.
And that usually takes place when it's a traffic stop and some sort of contraband, drugs, along those lines.
Sure, absolutely. Or even if someone's not supposed to be driving, if it's driving on a suspended license. Really anything that gets discovered after an unlawful stop can be suppressed.
Do you do some sort of training at all with local law enforcement? Do you have anybody that's designated? Or maybe people take it on their own to sometimes go out and train law enforcement in that regard?
Well, the State Attorney's Office, we have just ongoing training. We get training through other attorneys in the office. We'll go out on trainings that maybe the Florida Prosecuting Association, they might put on a seminar. We'd go to those. So we have opportunities to be trained in all different areas of criminal law. Depending on what we're interested in, we can even specialize in certain areas.
Your office also reaches out to police officers and law enforcement officers to train them to offer. I know y'all do, I think, quarterly newsletters to let them know about breaking developments with respect to criminal law. So to the extent that there are any changes regarding certain issues in a stop or certain issues in a search, you let them know about it so that they can adjust the way in which they investigate cases thereafter.
Absolutely.
Yeah.
We have a monthly newsletter.
There's a monthly,
that comes
okay.
out.
I'm
it's
so
called
sorry.
The Legal Eagle. And
The Legal Eagle. Have you ever written an article for it?
No, not yet.
Well,
They haven't asked
Mr.
me.
Hill Cooper was saying at the break how much he would enjoy writing an article for the Legal Eagle.
But it's true, we do work very closely with our law enforcement. I think felony intake probably works with them more than anyone else to let them know what things are appropriate and what things aren't. But it's an ongoing process. I think they can come in sometimes and we'll let them know how they need to be presenting themselves in court, need to be answering questions, because ultimately their world and our world are connected, but they're different. So there are things we can learn from them, but there are also things that they can learn from us.
Well, in fact, you have different roles. I mean, you're seeking different things in a sense, right? I mean,
that's absolutely true.
and explain that a little bit. Law enforcement's, they're doing one thing and you guys are doing another.
Right. Well, their role is to determine whether there's been probable cause for some crime. And ultimately, the state needs to be able to prove their crime beyond a reasonable doubt. So that's obviously a higher standard. We need to make sure that we can do that. And sometimes cases aren't appropriate to go, to be pushed forward. And law enforcement might not know that at that time.
And I think what I want to say that this is, once again, when I try to explain something to a jury, I said, listen, simply because you come back and find somebody not guilty, that does not mean that an officer has not told the truth. That does not mean that an officer has not done his or her job. That is simply representative of the different standard of proof that we have. Officers are out there doing the job, rushing to scenes that the rest of us would run the other way from. And they do amazing work under very difficult circumstances, and they are forced to make decisions with limited information. And that is the reason that we give them a lower standard of proof when it comes to investigating certain things or arresting people, because we know that there's no way that they can have the benefit of 6 months worth of hindsight and additional information and investigative reports and all these other sort of things that we flesh out during the course of a prosecution or a defense of a case. And so it's not, when it comes to you and you're 8 or 9 months after the fact, the officer, you may make the conclusions like, well, officer, I appreciate everything that you did, but we've learned all this other information. And I think they should know that that's not in any way an insult towards the job that they did.
Yes, and I think law enforcement's understanding that not every case that they present is going to go to trial and be guilty or even necessarily work out in a plea.
All right, folks, we've got to take a break. We'll be right back.
Mark McMann. I started McMann, PA after serving 10 years as a United States Army JAG Corps officer, as a military lawyer. That experience instilled in me certain attributes, including dedication, loyalty, sacrifice, hard work. I have made those attributes the cornerstone, the foundation of McMann, PA. If you're going through a divorce, a paternity action, a child custody battle, or perhaps a child support battle, call us at 863-393-9010 or visit us at McMannLaw.com. We are with you, honest, hardworking, and loyal every step of the way.
That's right. All right. Dude, that's my.
We never have anything played here. I think it's because you've asked him past 1985. Maybe 89.
Now we've had some 90s stuff there. The REM was big in the 90s.
No, that was 80s REM.
Well,
anything he
90s.
plays is 80s REM.
That is out of respect for,
no, I understand.
For me, his elder, his significant elder.
Significant, yeah.
Well, what do you want him to play, Mark? What music are you
well,
dying
90s alternative, like, so let's bring it, let's update it. Let's bring
you
it
like
to the
Depeche
90s.
Mode, don't you?
No, I wasn't a Depeche Mode.
No, don't even start. You loved it. On your playlist, I saw your iPod. It was George Michael, Depeche Mode.
I do like Culture Club, I will say that. I will
Culture
admit to
Club,
that, yes.
David Bowie.
No, David Bowie. That was before my time anyway.
Yeah. All right. Anyway, let's get back to
the
matters at hand. We've got Cooper Lord here from the State Attorney's Office, and we're talking about the prosecution of a criminal case. We've worked our way through the arrest.
We're up to trial now.
We're up to trial. Cooper, most of these cases work out. Sometimes they don't. Why does that happen? What happens? How do you end up in trial? You got a trial on Thursday. I mean, tell me. We're not going to talk about that, but how does that happen? And you've tried a bunch of cases.
Yeah, 30 cases. I think it all depends. I mean, it depends. Sometimes defendants, for whatever reason, think that they can beat it, and they just want to push it to trial. Sometimes that they've got a significant enough criminal history that they either don't have an offer or their offer is really high and they don't want to take it. But for whatever reason, cases just go to trial, and that we look for that at the State Attorney's Office. Ours is a trial office.
You want to say that, let me tell you something. The 30 trials, there are folks that have been practicing law for 40 years that do not get 30 trials. And I had more trials in my 3 years at the State Attorney's Office than I've had since I've left there altogether. I mean, you just don't get as many trials when you're out in private practice. It's not that I'm scared to go to trial. I enjoy going to trial. You just don't.
We're on the other side of it at that point.
Huh?
You're on the other side of it from the standpoint of, you're on the other side of it, so you're going to do what's best for your client.
Yeah, I mean, when you're a prosecutor, at least some of those guys down there, are looking to get rid of trials so they can, take it easy and coast a little bit. I mean, there's some weeks where you just don't feel like trying a case. You got the flu, you got whatever the case may be. There are some weeks you're just not up to it because it's a very stressful and draining experience to try a case. But the vast majority of the prosecutors up there, they want to try cases. And I remember when I was a prosecutor, if I found out another guy was, he had a bug or whatever, or he had the in-laws coming into town, he didn't want to try a case, whatever it may be, I would love to pick up trials, and I know you feel the same way.
Yeah, absolutely. I mean, I'm in a felony division right now, but I'm helping out with a misdemeanor trial this week just because I didn't have anything else going.
Because you're a giver.
Because I'm a giver.
So what does it take? I mean,
I'm a trial attorney.
To actually go to trial, say you have an ag assault kind of situation, or maybe you have some drug trafficking, but let's go with an ag assault. I mean, you have to prepare to do this. You have to prepare certain things. Go, tell me.
Okay, well, you're talking to your witnesses and your victims already beforehand, but you need to prepare them for trial. So there's certain things that they can talk about and they should talk about, and certain things they shouldn't talk about. You need to go over all of that with them. You need to prepare jury instructions, which are the law that's read to the jury by the judge. It's the state's job to present that. Sometimes you need to prepare demonstrative exhibits. You need to get all your exhibits that you're going to be introducing ready. You need to talk with your officers. Prepare for jury selection. There might be certain issues that you want to focus on. You might need to do case law research to be prepared for any objections that might come up or any legal issues that might come up. So there's a tremendous amount of things you have to do to get ready for a trial.
How important is jury selection from your prosecutor's perspective when it comes to going in and being successful in trial?
I think it's tremendously important because from my perspective, if you have one person that's going to hold up your jury, then that might just ruin all your work. Ultimately, jury selection is you're just trying to get a feel for the people that are on your panel. And what we're looking for are unbiased people that can sit on the jury.
No, you're not.
Yes, we are.
You're looking, everybody, let me tell you what it really means, folks. The defense attorney is looking for 6 people that will acquit, and the prosecutor is looking for 6 people that will convict, and we end up with 6 people that neither of us really likes.
Well, it's interesting because it's called jury selection, but it's kind of a misnomer because really what it is jury elimination.
Right.
The process is you remove potential jurors from the panel.
You get rid of the people that you think I want. They're called strikes. I go through and I get rid of people that I don't want, and there are strikes. There are challenges for cause that somebody comes on there and clearly is over the top biased one way or another. The judge will get rid of that person. But in most cases that we're dealing with, the defense gets 3 strikes and the prosecution gets 3 strikes, which means if you run across somebody that you think is going to be excessively leaning towards the defense side, for whatever reason you get that feeling, you're going to strike them, and you don't have to have any real reason other than that's just your instinct tells you that. And if I get somebody that I think is going to be for whatever reason leaning too heavily towards the prosecution side, I strike them. And this is not meant to be. I was kidding around saying we get 6 people we don't like. It's not that at all. We're not. This is not casting aspersions on their character. We're just saying, we want 6 people that we think are going to vote for us. I mean, that's all there is to it. And so at the end of it, you get 6 people that you're really not all that sure about. And those are the fair people, is what you mean.
Maybe the 6 least objectionable people.
6 least objectionable people. And these jurors do amazingly good work, and they're very dedicated. They're very dedicated. Okay, so you got these 6 people. What happens next?
Okay, well, after you've picked your jury, and that's on a Monday in Polk County, then the trials will go Tuesday through Friday, depending on what division you're in. So you're just getting your case ready. You have to do opening statement. The state presents their case, and the state has to prove their case beyond a reasonable doubt. So it's on us to prove with witnesses and with exhibits to get beyond that burden.
And when people hear that on TV, when they hear that on the radio, that the prosecution gave their opening statement today, essentially you're just basically telling the story, right?
Right. And you're saying what you expect for the evidence to show. The opening statement's not for argument. It's not called opening argument. That's saved for closing. But at the beginning, you're kind of painting a picture of what you think the evidence is going to show, putting it in perspective so that the jury, when they hear the evidence, they can put it in the proper frame of mind.
I agree. I'm just doing it from the defense standpoint. I mean, he paints the narrative that he wants the jury to begin looking for, and I do the same for the defense side. And so, he puts his version of events, and I put my version of events, and then we start putting the puzzle together.
And once you do that, I mean, you've told your story, then the burden's on you. You're the one that has to go up first. You're the one that has to put the evidence in. You're the one that has to put the witnesses up, right?
Right, absolutely. And David was saying that he presents his version of events, but sometimes that's not what you see. Sometimes the defense attorney, they're just there to make the state prove their case beyond a reasonable doubt. The defense ultimately doesn't have to prove anything. So they don't have to present an alternate scenario or different facts or even present any evidence.
That's true.
So you put on your case, and then after you're done, at that point, Dave or any defense attorney is going to ask for a JOA, a judgment of acquittal, at that point, saying, hey,
and it will be denied.
And it'll be denied, yeah. Saying they haven't proved their case, so it shouldn't even go, and we don't even have to put on our case, right?
Right, so that's a legal argument at that point, whether the state's presented a prima facie case, and the judge views that in the light most favorable to the state.
And then the defense can choose to either put on a case, not put on a case, or, well, put on somewhat of a case, but not have their defendant, their client, testify. I mean, that's something that sometimes clients will do or not do depending on how bad it could turn out on cross-examination.
Right, and the jury will be instructed that they're not to consider the fact that the defendant didn't take the stand, that he exercised his right to remain silent. Or if he takes the stand, or she takes the stand, then they're to be considered a witness just like any other witness that takes the stand.
Now, the jury goes out, and a lot of folks will, and sometimes even my clients will say, well, gosh, you seem to get along pretty well with that prosecutor. He's trying to put me in prison. What's the deal with that? I think it's important for people to understand that I don't have any problems with what the prosecutor does. I respect the job that they do, and I know that you respect the job that defense attorneys do.
Yeah, and I think it's important to have a good relationship, because if the defense attorney wants something out of the prosecutor, I mean, we're only human. And so if someone's just going to be just scorched earth and trying to get their way with everything and screw the state, then we're not going to want to cooperate.
Yeah. Who knows why certain defense attorneys do what they do, but
well,
God
good
bless them.
relationships. If you have a good relationship with the defense attorney, you're going to do things and work with them more, with somebody who's more affable, somebody who you get along with.
Well, somebody you
It's
trust. I
human
think that's
nature.
the most important thing.
Right.
That too, but also what you were saying, yeah, people who are friendly and outgoing, you're more likely to work with them.
Right.
To resolve
But I want to make sure that you're not giving away the farm simply because you get along with a certain defense attorney. But that questionable case, call about whether or not you want to object to that last continuance or not. It's a little bit easier to not object if the person on the other side is somebody that you know to be a kind and decent person, a staunch advocate for their client, but at the same time not the sort of person that's always looking to make your life difficult.
Absolutely.
And there's nothing wrong with me making your life difficult, but there's a time and a place for that.
Right.
All right. Folks, we want to thank you so much for tuning in to Law Talk, and we especially want to thank Mr. Cooper Lord for coming on today. I hope you felt like you were able to say a few more words than you did last time.
It was nice. This is fancy.
Yeah, we're big time here. Folks, we encourage you to come back next Monday at 5:07 p.m., in which point we will have Bob Laddick with the Department of Corrections on. Until then, thank you for tuning in to Law Talk.
Happy
Mark
4th of July.
McMann, happy 4th of July, and God bless this wonderful country.
And happy Canada Day.
Happy Canada Day. Cooper is half Canuck.
Yeah.
So, anyway, we're out of here.
Hello, I'm Mark McMahon. I hope that you enjoyed the episode that you just saw. If you have any questions about us, you can contact us on our website, lawtalkflorida.com, or you can contact me at mmcmahon@mcmahonlaw.com.